with regard to the permanent residence. That's something fundamental in 54 order. So what I am trying to show is that there are orders which go to the very root of the matter and which continue to remain as they are till date. They have not been diluted. Subsequently, other provisions like 356 subsequently applied, 136 subsequently applied, but they are matters between the union and the state. But then on the broader parameters, the state continue to have its autonomy. That's all I am trying to indicate. By virtue of each and every, I have noted each and every article. It deals with what was the subject matter of the article in the Constitution, and how by the order of 1954, a certain position, especially for Jammu Kashmir, was carved out.
Mr. Shah, can you just, to sort of summarize, can you tell us on the eve of the CO of 5th of August 19, which were the key provisions of the Constitution to which an exception still existed in relation to Jammu and Kashmir?
So let us say Article 3.
So we can really summarize those, because that will give us the net position as on the date.
Very true, sir.
There's two ways of looking at it. We can look at the chipper way, or we can look at it from your perspective, which were the core which was still left intact, and which now the abrogation completely, sort of.
I need to watch with a full chart. That what?
35.
That what was the position on 4th of August 2019, even after application of these constitutional application orders? What was the position as on that date? That's what your lordship wants to know.
Yeah.
Some of the articles which I read.
Every one of those provisions which was modified as on 4th of August 19, if you can give us the core to sort of buttress your argument that, look, despite the chipping away, this core had remained intact as on 4th of August 2019.
Very true. I can give that. We still had some autonomy. I'll give some fundamental. Let's say anti-97. We may not go that far also. I can give example of the best example, anti-97. Who had the residuary power? Who had the residuary power to legislate?
Interestingly, both the state list and the concurrent list were deleted in application to the state of Jammu and Kashmir. You'll find that, I just saw it a little while back.
That's what I think it is.
Part 11, see page 16. Page 16 of volume 3, if you're in the same volume.
Yes.
It says in Article 246, the words brackets and figures, notwithstanding anything in clause 2 and 3 occurring, and clauses 2, 3, and 4 shall be omitted. So basically what happened was, in relation to the state of J&K, you had only the union list which was existing. Insofar as it applied to the state of J&K, the entire state list and the concurrent list had been deleted.
But subsequently, you should also see this.
Thereafter, maybe some items in the state list were brought in. Maybe the concurrent list was also brought in.
I think you also needs to give me some time. It is also subsequently changed in CO 66. This 246, which you also read, clauses 2 and 3, occurring in clause 1 to be omitted. That was the original one. 3 and 4 is also omitted.
So, really speaking, we therefore take it, Mr. Shah, that we don't have to go through these articles to buttress your point, but your contention is that there was a very substantial degree of autonomy which was reserved to the state as a consequence of Article 370. That was not merely with reference to enacting laws, which we saw in Clause 1, but it was also in relation to other provisions of the Constitution, which would not apply unless there was a concurrence of the state.
I thought I would indicate in specifically, one would be a general position of law, that there was a constitutional autonomy with you. What earlier it was, if I put it in terms of quantum, if it was something like 100 grams, but even then I retained 30 grams by the time it was 4th August.
Perhaps, Mr. Shah, what you can do is, maybe without us going into it right now, later on, even after your argument is concluded, you can give us the core areas which had remained for the state as on, the original Constitution.
Specific area,
right?
I can give.
You can give it to us as of, say, the 1954 order.
Yes.
And then you can give us what still remained with the state as on 4th of August 19. So we can have a comparison.
Yeah,
You can do it in 2 pages, that's all. Don't give us a very elaborate statement. That will buttress your point. So we appreciate it. That's all that we.
I had done it my way. I had done it specific article wise. Each and every article, that's what I was trying to show. But if you also want me to give it writing, I will give that.
I think just, on a
But
page,
take care of that.
the one page of the position as it stood in 1954, one page is the position as it stood on the eve of the abrogation. That will really support your submission.
But I'll give that.
So that we don't have to then read individual articles unless there's something key that you want us to see,
No, what's important is this, as I said earlier, why are we aggrieved of 5th and 6th? If nothing was with us. Why are we aggrieved? Why are before 22, 25 petitions have been filed? There was something with us. I was trying to show what is that was with us. Otherwise, if there was nothing with us, it would not matter. It was an empty formality.
There was something with you, and
Yeah.
there was a
No, whether they could take
emotional
it.
context to it.
Whatever little sir I had with me as a constitutional autonomy, whether they could take it away.
No,
Not
that's why I
that little.
said 2 things: emotional context and something which remained, actually also remained.
True. What I'm submitting is only, I'm in a response to only Chief Justice's observation that you indicate only what kind of autonomy you had on that date, on 4th of August. I will certainly indicate that.
And even earlier, because that will support your submission.
This was earlier what I had in 54. Is it also willing to go into the question that 54, what you got, and over the subsequent CO orders, what you lost at what stage? I can take one by one your lawsuits on that. What I lost subsequently, but ultimately it ended up on 4th.
Yes.
But if what you say is on
You're
4th,
ultimately
what autonomy
concerned
you
with-
had, indicate that, I will do that.
On 4th August,
I did have
as
my autonomy.
370
on 4th.
stood, what is that which were with you, which you have been denuded of by repeal of this?
So take it on the face of it, I can say so just from my heart without supporting it. Let's say, because I was a permanent resident of the state, I had my own law. I had own privileges, own rights. Isn't that taken under? It's as simple as that. Just to your lordship's knowledge, as simple as that. My state could not have been divided into union territories. Isn't that taken away? What Honorable the Chief Justice says, you tell me the solid ones which you lost, not the other things appeal to Supreme Court or otherwise. These are few of the solid ones which come to one's mind. I lost that. I lost my legislature, lost the power to make the laws in respect of those matters where it had the power, maybe little power, but it had the power, particularly entry 97. It made certain laws, it made certain changes, but now that is also gone. Preventive Detention Act is also gone. You'll also have seen in the Organization Act how many laws have been repealed. Consequent to
Mr.
this.
Shah, to buttress your submission, we are saying something, which will enhance, which will further your submission. Just look at page 16 of volume 3, in case, I don't know if you are using the same, we are on the same page.
I'll just have a look.
Volume 3, page 16,
1/6, sir. Just
1/6.
never mind.
Mr.
Digital.
Shah, somebody can give that. to
Yes, sir.
Mr. Shah, so that we are on the same page.
It is
Then.
not 16.
Page 16, you've got that middle of the page, part 11. Part 11,
Oh,
PDF page 16,
yes, sir.
right? So part 11, right?
Yes, in
A.
Article 246.
In Article 246, the words brackets and figures
2 and 3 of the clause so and so shall be omitted.
and clauses 2, 3, and 4 shall be omitted.
Yes,
In other words, Article 246, which recognizes the power of the state legislature to enact laws on the state list, and the power of Parliament to enact law on the concurrent list was deleted in 1954.
yes.
Now, just go to page 19, PDF page 19. Go to the 7th schedule, page 19, you will see entry 22, 7th schedule. Just give Mr. Shah the page, Mr. Shankar.
19, this was CO, this is CO 55?
No, 54. We are on CO 54 only now.
Just one minute, I'll show you.
3 pages down,
Yeah.
just turn to where
Yes, sir.
the Schedules are listed.
Seventh schedule, yes,
Right. Now, in the seventh schedule, in the union list,
yes.
just go a little down, item 2, where it says entries
Eight, nine,
so and so, the words interstate migrate, and entry 97 shall be omitted. Therefore, entry 97 is completely omitted.
Yes,
Now, go to the last clause of 22B. The state list and the concurrent list shall be omitted.
yes,
So, the net result in 1954 was Parliament had the power to enact laws with respect to some entries in the union list.
union list, yes.
The entire legislative domain of Parliament on the concurrent list was obliterated, and the state list was also deleted because the entire power of legislation, the legislative power, was given to the state legislature. This is the autonomy which you are saying,
Yes.
isn't it?
This is what I thought, but I could specify also what was left. My question is very extremely important. What was left on 4th of August? I said.
Now we'll go to the 4th of August because that's the part, the chipper way there.
What the chief is pointing out in a larger conspectus, what you are saying is 54 reflects a larger conspectus. Larger conspectus is that list 1 as specified, list 2 omitted, list 3 because list 2 already vested with you. Thereafter, as you say, chipped over. So this gives the larger, in support of your argument, the larger context of it.
No, if I am satisfied, not me, your lordships are satisfied that on 4th of August, there was constitutional autonomy, some constitutional autonomy. What was its quantum? How much it was is a matter of detail.
Reflected in it at lunch, you're almost in the stroke of lunch. One way of our doing it is, after the 1954 order, read every order and see the chipping away process. That will unnecessarily take a lot of time and it will be tedious. What we were suggesting was that you can give us the net position as it stood on the 4th of August 2019. So we'll realize then, we've now seen the 1954 order, which gave a very substantial autonomy. No doubt about it. That point you have made. We need to labor the point further. Now we look at what was the position on the eve of the abrogation, which is 4th of August 19. Because your argument will be that even as on the 4th of August 2019, notwithstanding all the subsequent applications which took place, there was still a core left with the Jammu and Kashmir State Legislative Assembly. So you can give us, like we have now done for 1954, some 3 or 4 examples, and you can put the rest on a piece of paper, just sort of putting it all together.
I can put it entry-wise, this entry, this entry, this entry, that I can do.
But just confine it to the key areas, because that will buttress your point, isn't it?
That's the problem, which is a key area.
No, I mean,
I have some
where the rub lies.
States being together, unified state is a key area. Who is a permanent resident is a key area.
right.
These are the key areas.
So can you just summarize them after lunch for us? Which are the key areas, so that then we can move on to the rest of the argument.
I'll do that. I'll do that. So that
Got the drift of the argument. We just thought that we should have some illustrations, which are the key illustrations that will sort of, drive the point home.
unless your lordship were writing the judgment would be very specific. Look here, the state still enjoyed its autonomy in respect of A, B, C, D. That's being specific.
Right.
Second would be also would say they did have some.
What has been
was
taken,
that some?
what has been taken away by the under the provisions, which are
Yeah,
you on the.
what has been taken away, what was left with us? What would be general statement making, sir? I had, as I tried to give example, 100 grams with me, they took 70, 30 still with me. But what was that 70, what was that 30? I thought that I would deal with it in more specific terms. This is taken and this is with me, rather than being general about it. That's what I was trying to.
The only thing is time in all this becomes a little constraint. Now, yes, there was a position in 1954. We've understood your position in 1954. That at various times to time something may have been chipped away.
Yes.
Is there when and how is not before us, because that's the most factor situation.
Yeah, very true.
As you also argue.
Very
Now, something happened which is under challenge. So
Yes.
a pre-challenge position for us to appreciate what was the pre-challenge situation which has been deprived in the result of what you have challenged.
Yes,
So
yes.
this was a little extent.
I'm with your lordships. I'm with your lordships.
We have understood your broader arguments on consultation and concurrence. Now we just would like to know what was the residuum which was left on the eve of the
What
abrogation.
was left of constitutional autonomy? in simple language.
As you said,
What is left of constitutional autonomy?
there was something left. What is that something is the only thing we are wanting to know.
All right, we'll just look at it after lunch. And just, yeah, one, two, three, take a look.
Part 6 was not applied.
Go ahead. Mr. Shah, now what is the rough time estimate for you to complete?
I need to still argue, so I have some problems I need to argue.
About, should we give you another hour or so? Can we wrap up in an hour so that then
No,
the
sir,
next
no, sir,
person?
more than that. Actually, more than that. I would regret it might spill over even because I have some more to say.
That's all.
I know all of you have some things to argue. Our constraint is also at some stage things have to end.
Give me that little freedom.
With all your ability, I'm
As
sure
a-
you can. With all your
As a
ability, you can.
Important case for us.
Of course, we understand.
Important
That's why
case
we are
for
giving
the
so
state.
much of time.
And
Of
there
course,
is
Mr. Shah,
some
no
freedom
doubt
given.
about it. Mr.
These
Shah,
are
can we
going
do
to
this? Can we
the
suggest,
satisfaction.
can we suggest this after lunch? You can give us broadly the themes on which you are going to argue. Just formulate the themes so that we also have a clear picture that how you are now going to unfold the rest of the argument. Just give us the 3 or 4 themes that you're going to argue and show us under that theme, then we'll know what exactly you are.
As you know.
That will be better.
All right.
Thank you.
Thank you.
Photo, yeah.
check.
Yes. I think now we'll focus on each of these themes. The first one you've actually covered, I think.
The permanent nature of
Yes.
Article 370.
Yes.
Except few sentences I would like to use. One is that when it was originally enacted by the Constituent Assembly at that time, they rightly termed it as temporary. Rightly. Because at that point of time, the position of the state of Jammu and Kashmir was totally unclear. As I said, it had an external dimension and it also had an internal dimension. The external dimension was because of UN Security Council resolutions, and the internal dimension was because of the letter of Governor General dated 27th of October, 1947. So therefore, the Constituent Assembly thought that the Constituent Assembly of the state would recommend application of the Constitution of India directly to the state of Jammu and of course, through Article 370. They proceeded on that assumption. I am entitled to say so that this was an assumption made that the Constituent Assembly would do. Realize, could not actualize. This is the reason I'm giving. So this continued, this position continued till 1957. Since the power vested with the people, as also under instrument of accession, as also under proclamation of Maharaja, had three sources to make the constitution. Therefore, the Constituent Assembly made a separate constitution for the state of Jammu and Kashmir.
Which were the three sources you said? The instrument of accession?
One was instrument of accession, second was proclamation of Maharaja of 1948.
Yes.
Now, when it adopted,
And which was the third?
what I said was this letter of 27th of October 1947
Yes.
of the Governor General. Now, since the fate of the state was uncertain, therefore they left it temporarily. It could be a part of union, it could not be a part of union. But in the meanwhile, the constitution of the state was made. Now we are again concerned, those are the political aspects of the matter, what happened at that point of time. I'm not going to that question, or my lords are going to adjudicate those issues. But the fact of the matter is that right from 1951 till 1957, when constitution was made, so we, at the end of 1957, in fact, January 1957, now we got two. One was the Constitution of India as was applicable to us, and second was our own constitution. This is the situation 1957, and this is the source of the constitution of the state of Jammu and Kashmir. Now, what is contained in the constitution of Jammu and Kashmir could not also be contained in the Constitution of India, that they would be in conflict. So therefore, all those provisions of the Constitution of India, which could come into conflict with the Constitution of Jammu and Kashmir, were not made applicable to the state of Jammu and Kashmir. Now, few of them which are extremely important as we proceed ultimately to determine the constitutional validity of the action taken on 4th. My lords, may have a look at the Constitution of Jammu and Kashmir. Page क्या उनका क्या volume? M2. My lords, in volume 2.
The page of volume 2.
So 232, general page. Volume 2, 232.
PDF 232?
PDF? PDF? 7.
Yeah.
This constitution is given by the people of Jammu and Kashmir. The Constituent Assembly was constituted in terms of the notification of the then here of the king, that is Dr. Karan Singh, on 20th of April, 1951. And in terms of that notification, which is also part of my Lord's records, elections took place on the adult franchise. People's representatives were elected and they became the members of this Constituent Assembly. Now, what did the Constituent Assembly do? It ensured, if I generally say it, it ensured that the state of Jammu and Kashmir shall continue to remain the integral part of India. So on that part, it is there. Second thing, it ensured that the provisions of the Constitution of India will be made applicable to the Jammu and Kashmir. Two provisions there, Section 3 and Section 5. The Warlords will have a look at Section 3. It says state of Jammu and Kashmir is and shall be an integral part of the Union of India. Page 18. PDF. The 4 is territories of the state. 5 is extent of executive and legislative power of the state. The executive and legislative power of the state extend to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. Now read this with Article 370. Means the state legislature will not have any power to make the law if Parliament of India has that power. But where from the Parliament of India will get that power? Only with the concurrence of the government of the state under Article 370. Five, the executive legislative power of the state extend to all matters except those with respect to which Parliament has power to make laws for the state. So laws for the state to be made by the Parliament was dependent upon the concurrence to be given under Article 370. Except those which were in the instrument of accession, consultation was required there. It was dependent. So this 5 we need to read with Article 370 and the power of the Parliament which is given to it. So all other powers which were not, in respect of which no concurrence was given under Article 370, obviously the Parliament would have no power to enact laws. And the power would vest in the state legislature in terms of Section 5 itself. This is how we read how Section 5. Now, provision is also made of permanent residents. How does this get protected? This gets protected by the proviso to Article 7 of the Constitution of India. Then, sir,
Yes.
seven is construction of reference to state subjects in existing laws, legislature to define permanent residents, special provision for bills related to permanent residents. Now come to 10. Rights of the permanent residents. The permanent residents of the state shall have all the rights guaranteed to them under the Constitution of India. It gave them the rights which were available under the Constitution of India. For permanent resident, he had to be a citizen of India first. After 1954 application, he had to be a citizen of India first. Then only he could be a permanent resident. During the Maharaja's time, 1927 notification and 1932 notification had nothing to do with being a citizen of India, because at that time, India as such did not exist. So therefore, they were brought, these two notifications which are protected under this constitution. They carried a condition with it that you have to be a citizen of India, then only you can be a permanent resident. And their rights would be those as are available under the constitution. Now look at now directive principles of state policies. Now the provisions in the Constitution of India relating to direct principles do not apply to us because the state constitution has its own directive principles. Now comes the important part, that is part 5, exec to the governor. This part is extremely important in a certain perspective that I will indicate, which is one of the arguments which I propose to raise. Now, who is the head of the state? It says the head of the state shall be designated as the governor. There was a change earlier, it was first Maharaja, then Sadr Riyasat, now it is governor. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or throughout subordinate to him in accordance with this constitution. Nothing in this section shall be deemed to transfer to the governor any functions conferred by any existing law on any other authority, or prevent the state legislature from conferring by law functions on any authority subordinate to the governor. Appointment of governor. The governor shall be appointed by the president of warrant under his seal, hand and seal, provided that the person holding office as Sadr Riyasat immediately before the commencement of the Constitution Jammu and Kashmir 6th Amendment Act shall on such commencement be the governor and shall, subject to other provisions of this Constitution, continue to hold office as governor until the remaining period of his term. The governor shall hold office during the pleasure of the president. The governor may, by writing under his hand and address president to resign his office. Subject to foregoing provisions of this, the governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that he shall, notwithstanding the expiry of the term, continue to hold office until his successors enters upon reference. Qualification: no person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 30 years. Conditions of office: the governor shall be a member of either of the office. Governor, he shall be deemed to have vacated his seat on the house, in the house on the date on which he enters upon. The governor shall not hold any office of profit. The governor shall not be entitled to
Yes, we've seen
shall be entitled to such emoluments. Now, what is important is in this, the oath which he is required to take. That is section 31. The governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court, or in his absence, the senior-most judge of that court available, on oath or affirmation the following form. That is to say, I so and so, that I will faithfully execute the office of governor or discharge the function of the governor of Jammu and Kashmir, and will, to the best of my ability, preserve, protect, and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of the state. And the governor stabbed the people of the state in the back. He committed serious breach of the oath by making a recommendation to abrogate Article 370, which he could not do. Had he been a sitting governor, perhaps impeachment motion could have been moved against him. He is to uphold the Constitution of Jammu and Kashmir, and he destroys it by his recommendation to the president that you apply all the provisions of the Constitution of India to us, which even the Constituent Assembly did not do. He requests the President of India, you change the Constituent Assembly to Legislative Assembly. And the President of India is pleased to accept the recommendations of the governor when he acts in breach of the oath of the Constitution of Jammu and Kashmir, which is serious constitutional misconduct committed by the governor. And in this particular case, there is no evidence produced. Nothing is stated in the counter affidavit. When was the recommendation made? Who made the recommendation? At whose instance the governor made the recommendation? I have a very serious duty to submit before this honorable court with regard to this role of the governor in making a recommendation when the state was under president's rule. And sir, see 35, Council of Ministers to aid and advise the governor. Council of Ministers to aid and advise the governor, section 35. There shall be a council of the chief minister at the head and aid and advise the governor in the exercise of his functions, all functions of the governor except those under, now see this is important, all functions of the governor except those under section 36, 38 and 92 shall be exercised only on the advice of council of ministers. Means that he had a subject to satisfaction in respect of three provisions, 36, 38 and 92 and none else. He cannot act of his own. Under any provision of the constitution of the state, and much less he could act under Article 370 in making recommendations to the president. And this governor has been spilling beans all over the country. According to one of his press statements, he was asked to sign on the dotted lines. That you also will find from the records because we have no access to those records. Thirty-six is the appointment of ministers, responsibility. Then appointment of Advocate General, conduct of business, composition of the state legislature. We have the seats reserved for the territory which is occupied by Pakistan in section 48. And you see this, we have then composition of the Legislative Council. We had a bicameral legislature, assembly also and council also, that is section 50. And CSR 51. Qualification for membership of the legislature. A person shall not be disqualified to be chosen to fill a seat in legislature unless he is a permanent resident of the state. They alone can be the members of the legislature. And so directly kindly go to section 92. Obviously, these provisions are not in the Constitution of India. If at any time the governor is satisfied that the situation has arisen in the government of the state cannot be carried on in accordance with the provisions of this Constitution, the governor may by proclamation assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by anybody or authority in the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to anybody or authority in the state, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in the High Court. Any such proclamation may be revoked or varied by subsequent proclamation. Any such whether varied under sub 2 shall accept when it revoking a previous cease to operate on the expiration of 6 months from the date on which it was first issued. If the governor by a proclamation under this section assumes to himself any of the powers of the list to make laws, any law made by him the exercise of that power shall subject to terms thereof continue to have effect unless 2 years have elapsed from the date on which so and so. No proclamation under subsection 1 shall be issued except with the concurrence of the President of India. Every proclamation under this section shall, except where it is a proclamation revoking a previous proclamation, be laid before each house of the legislature as soon as it is convenient. Now, what's important in this is the same thing as in Article 356, that when you cannot carry on the government in accordance with the provisions of the Constitution. That is the subject of 92, and that's also the subject of Article 356. Now, the question for Lordships is that on the basis of pre-existing constitution. If the government cannot be carried on, whether the constitution itself should be changed, or you have to see only that the government is not being carried on according to the constitution, which was prior to any alteration or change made in the constitution. My submission is that nothing can be done when 92 is in operation or 356 is in operation, because the subject is only that governments cannot be run according to the constitution. No power vests in any authority to amend the constitution, whether it is 92 or 356. None. Just on an analogy, I'll just seek your lordship's consideration to Article 34. Of the Constitution of India.
Article 34.
34, yes. Just by way of analogy, I'm showing. Notwithstanding anything in the foregoing provisions of this part, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was in force. Or validate any sentence passed, punished, inflicted, forfeiture, ordered, or other act done under martial law in such area. If such a situation would arise, would this court countenance that the chief martial law administrator will abrogate the Constitution of India because it doesn't suit him? What is the power with him? I'm trying this as an analogy that even if there would be a case of martial law, the Indian Constitution, the Constitution of Jammu and Kashmir, do not contemplate, envisage, nor can be conceived of that during the operation of 92 or 356, any change in the constitutional relationship can be made. That's my contention of the lordship's consideration. Then, sir, in our state constitution, it is 93, that is the High Court, appointment of judges, qualification of judges. All those incidental provisions are provided. And if the transfer is to be made, the concurrence of the governor of the state has also to be obtained upon a transfer of a High Court judge to the High Court of Jammu and Kashmir. That was the position prior to 4th August. Our High Court had its own power of issuing the writs under section 103 and 104. Then, sir, we had our own Public Service Commission in terms of section 124, with all incidental provisions relating to the members. And 126, which corresponds to Article 311, giving protection to the government servants, that was also there. So these were the different provisions. Now we come to the, which reference has been made, 147. Official language, Academy for Development, protection of governor, all those provisions are contained in the Constitution of India. When we see 147, an amendment of this constitution may be initiated only by introduction of a bill for the purpose of the Legislative Assembly, when the bill is passed in each house by a majority of law less than 2/3 of total membership of that house. It shall be presented to the governor for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill, provided that a bill providing for the abolition of the Legislative Council may be introduced in the Legislative Assembly and passed by it by a majority of the total members of the Assembly, by a majority of not less than 2/3 of the members of the Assembly present and voting. Provided further that no bill or amendment seeking to make any change in, the word amendment is not there, but seeking to make any change in this section 147 itself, the provisions of 3 and 5, or the provisions of the Constitution of India as applicable in relation to the state. Now, this is relatable to clause D of Article 370, which provides for the application of the constitutional provisions with or without modifications. It means it prevents the state legislature from making any change in that relationship. दे दो पहले निकाल CO273 CO273 page 496 volume 4 496.
Argued covered, I think, item, your submissions 1, 2, 3, 4, 5. The first 5 themes you have covered, I think.
Yes, sir.
Whether Article 370 has become permanent with the passage of time. 2, whether the autonomy of the state is to be determined not only by the laws applicable to us, but also by the Constitution of J&K. 3, whether CO 272 is constitutionally valid because the state was under precedent's rule and no change in the constitutional relationship could be made when presidential rule is in operation. 4, because the Council of Ministers not being in place, no recommendation can be made by the governor. 5, no evidence produced with regard to the recommendation of the Council of Ministers or the governor who acted in breach of his oath and was thus liable for impeachment.
These are the themes pursuant to the Lord's observations, but they need to be expanded.
But you have now shown us in the last
something more to show.
last 35 minutes, you have shown us now the first 5 themes, I think.
In this, Your Lordship, may kindly have a first look at page 496, that is CO 273.
Which volume? Same volume?
That is the second notification.
Volume 3 page. The 6th of August, 19.
This is in continuation to what I am submitting. All provisions of this Constitution, this is the resolution of the Parliament, sent to the President, and there's a declaration issued by the President. But what is done under this is important. I'm reading it for that purpose. I have different arguments to make. All provisions of this Constitution as amended from time to time, without any modification or exceptions, shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in. Now, this is important, what has been taken away. Article 152, Article 308, or any other article of this Constitution, or any other provision of the Constitution of Jammu and Kashmir, or now this is any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom. Something is wrong with this subject one. Regulation, notify, custom or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged under Article 363 or otherwise.
What would be your submission? How will you formulate your submission on this aspect?
I'm saying this, that what is sought to be done in terms of this was with me.
Sorry?
They do away with my constitution. They do away with instrument of accession.
Yes.
Now, so let's see once again this, my submissions with regard to this CO 272 and 273. That's very important to us because that's where the court is to adjudicate primarily the issue. 272, 273. इसका दिखता ही नहीं मुझे, इसका गायब हो जाता है. Let us take a close-up of this 272 first, because in my humble submission,
Same.
One page up.
if 272 goes, then 273 goes, Reorganization Act will go. We'll take a close-up of this. And exercise the powers conferred by Clause 1 of Article 3 of the Constitution, the President with the concurrence of the Government of Jammu and Kashmir. I'll pause here first. It says Government of Jammu and Kashmir. I have a different meaning of the word Government of Jammu and Kashmir. If you also have a look again at Article 370. Explanation: for the purpose of this article, the government of state means the person for the time being recognized by the president on the recommendation of the legislative assembly of the state as Sadr Riyasat in Kashmir, acting on the advice of the council of ministers of the state for the time being in office. Now this Sadr Riyasat gets changed into governor by an amendment not carried out in the explanation, but carried out in the Constitution of Jammu and Kashmir, 6th Amendment Act. What I'm saying is this expression on the aid and advice of the Council of Ministers. I pause here. When we're using the word government of the state, the Article 370 and its explanation defines as to what is meant by government of the state. Government of the state can exist without council of the ministers in the normal parlance language. We say this is the government of the state. There may be a council of ministers or not. But what 370 envisages is a government of the state which is aided and advised by the council of ministers. Not simply sit a government of state. Government of state is there always. Emergency, no emergency, president's rule, no president's rule. The government of the state is always there. But a distinction is made in Article 370. It is that government of the state which has the benefit of the aid and advice of the Council of Ministers. I consider this to be the extremely important part of the power to be exercised by the governor as the head of the state in making any kind of recommendation to the president. Admittedly, the state is under president's rule. Admittedly, Section 35 of the state constitution is suspended. But what's more important is this, that in terms of the presidential notification, the President of India assumes to himself the powers of the governor, not only under the Constitution of India, but also under the Constitution of Jammu and Kashmir. I have it somewhere. The
The
presidential.
president assumed the powers.
Under the presidential notification, the President of India assumes to himself the powers of the governor under the Constitution of India, as well as the powers of the governor under the Constitution of the Jammu and Kashmir. Both. तुम लोगों को notification. Volume 3, उठा रहा।
To interpretation clause in the 367 made for the first time,
When was the 367?
as applicable to the state of
Modified
Jain.
form. That was in 54 order.
54, not afterwards.
Afterward, there was one more occasion, I'll give Lord. So my Lord stopped me, otherwise I would have given all those details. 367 has its own 3 times.
3 times.
First 54, thereafter one more time, and lastly under 2000.
So that last we know.
And meanwhile also there is.
In
Oh,
between,
yes, I don't know. It is in 1966
okay, 54, 66,
and 2019.
2009.
Now, why that? No, there's a why part of it. No? In 54, we agreed, and that is stated there. What is important is 66. Prior to 66, in 1965, the Sadri Riyasat was replaced
By the
by
governor.
governor. So obviously, the constitutional application order of 66 said that reference to the Sadri Riyasat
Will be in
would be
reference to the
reference
governor.
Right.
Why did it say so? Also because this expression Sadri Riyasat had appeared in explanation. That explanation is in the Constitution, Article 370, and it said that you can amend 370 only if recommendation is made by Constituent Assembly. Since in 66 there was no Constituent Assembly, so Sadri Riyasat got stuck up in this explanation, in order to overcome that difficulty, they said read Governor for Sadr Riyasat, but important fact is that first the amendment was carried out in the state constitution, not without that. Therefore, it became the chief minister, the prime minister became chief minister, Sadr Riyasat became governor in 65 amendment carried out in the state constitution.
So there was amendment, first was 1954.
Then 66,
But
then 2000.
1954 also, but in 1954, there was no need for that. Because till 1954, the Constituent Assembly was still in session.
There were Raj Pramukh, there were. so
But
many other things
just
were there.
until 1954.
Yeah.
And therefore, clause 2 was applicable. Clause 2 to Article 370 was applicable. But still, they made the amendment in the definition or the interpretation clause.
No, my lord's observation gives rise to one serious question. That is whether 367 also is a source of amendment. Keswananda Bharti can be, you can get rid of it simply by amending General Clauses Act. That the amendment shall include amendment of part third. That is end of the matter.
Mr. Shah, we will not go
What should
into
the
that.
30 judges
No, that question need not be gone into. Let's put it very.
That question need not be going into.
One thing is very clear, that the 370 was a flexible article. It was always meant to be a flexible article.
When my lords are saying flexible article in this sense.
Yes, but with the concurrence or that your argument to that effect.
Flexible in this sense, there's a perspective, flexible in the sense that the provisions of the Constitution of India or the lists 1 and 3 could be made applicable to the state. Of course, to that extent, it was flexible. But its own self-abrogation, it is suicide, its own killing. Whether it was possible to do by the government or by some external authority.
You have argued on that.
No, I am still arguing on that, but I'm saying it. No,
There's another point of view also. You have argued because there's another point of view.
Sir, whenever I said that, this case turns on the powers. My lords are interested in power of president, governor. That is the basic theme in all of my submission is that the power, I'm dealing with the issue of power. Now see, this journal page 485,
Just
not
one
volume
second.
third and
We
3.
wanted 2 amendments to Article 367 have found.
Volume 3. Page number?
38. It says 65. Volume 3, page 18, volume 3, page 39. Those are the two. What next,
Now, see,
Mr.
My lords, see this notification. I so-and-so received a report from the governor of the state because 6 months had expired. And under 92, the governor's rule could be only for 6 months. And after considering report, other information is where I am satisfied such a reason in which the government of that state.
Where is that notification?
So I'm reading 19 December 2018 notification. Page.
Page? $92, no?
Simply, sir, kindly. Now, therefore, in exercise of powers conferred by 3/5 Constitution, all other enabling, I hereby proclaim. I assume to myself, as President of India, all the functions of the government of the said state, and all powers vested in or exercisable by the governor of that state under the constitution and the state constitution. Now pause here for a minute. What power the governor had first under the Constitution of India? He is the appointee of the state government, appointed by the president, but functions under the Constitution of the state of Jammu and Kashmir. His qualifications, his emoluments, he takes oath under the Constitution of Jammu and Kashmir.
But holds office during the pleasure of the president.
Very right. Now, when he assumes to himself the power of the governor of the state, this is the important sentence I'm reading. For purpose of 370, now who is governor? Who can make recommendation? If the president says, I am the governor, I have taken all your powers, then for purpose of 370, who has to make that recommendation that you do away with Article 370? You apply all the provisions of the Constitution. The president himself or somebody else. When the president delegates, that delegation is subject to direction, control, and superintendence of the president. Means the governor is the delegate of the president. Now, is it a case where an agent and a delegate recommends and the principal accepts? Does it commend itself to our sense of justice that where the president of India has assumed himself the power of the governor? I am saying that no power vested in the governor of the state of Jammu and Kashmir to make any kind of recommendation on the basis of which CO 272, 273, 272 was issued. No power vested because it is taken over by the president and he could not have recommended to himself the abrogation of Article 370. So again.
Yes, Mr. Shah.
So when he assumes to himself this jurisdiction, that's what I'm saying this, I'm dealing with this case on the basis of the power. When he assumes to himself this jurisdiction that I am the governor, I really fail to understand then who could make the recommendation under 356. And the opening word of CO 272 is, we have a look at 272 once again, sir. In exercise the powers conferred clause on the president with the concurrence of the government of Jammu and Kashmir. That government of Jammu and Kashmir is defined in explanation appended to Article 370. Means the government which has Council of Ministers in place. Why did the Constituent Assembly of India expressly provided Sadr Riyasat, aid and advice, Governor, aid and advice? It is repeatedly, even under 367 modified form, reference to governor is aid and advice. What is entrapped in this? Because one way of understanding Constitution is simply by the text of it, going by the words. Second is, which I am submitting is for Lordship's consideration, is the legal value which is entrapped in that provision. What is the legal value entrapped in this provision of 370? Council of Ministers, if I put it, doesn't it show the political presence of the people? Doesn't it show representatives of the people are present? Doesn't it have the element of democracy that people are there through Council of Ministers, who alone are answerable to the legislature. So what is entrapped in Article 370 is not what is textually written. But we need to interpret this 370 in terms of the purpose it has. I'm submitting for Lordship's consideration is that purposive interpretation needs to be placed on Article 370.
Yes.
I request your Lordship to have once again a look at CO 272, and for the benefit of Honorable Justice Khanna, with Article 367 as it was applied.
Mr. Shah, if you could just, so that will bring clarity to us. We've made our notes when you were arguing. Can you now on this aspect just crystallize your submissions in 1, 2, 3, 4? We'll take it down so that we have it in one place.
If I have to go by the.
So we now,
Which I
we've
gave
seen
to
CO 272, 273, but if you can formulate it so that it'll bring, structural clarity to the whole discussion.
One of the first one which I submitted also was that 370 is a permanent.
No, you need not go that far back,
No,
just on this aspect.
I'm just reading to what you I gave.
Oh, okay. No, that we have seen. No, I was not on that. What you just said
Yeah.
about 272, there if you can just formulate your submissions. Whatever you covered earlier, that we've got very detailed notes. This part, if you can just formulate
The
it.
challenge to 272.
272, right?
Challenge to 272 as an independent.
Without expanding, the Lordship's giving me the pleasure of being here and hearing in detail. Challenge to 272 is first.
Yes, just a second.
When the presidential order is invoked under 356 is point number 1.
Sorry,
Point
can you just come again?
356.
No, can you just start from the beginning? Or when the presidential?
272 is notified, issued at a stage when presidential order under 356 is in operation. Number 2.
Yes.
That the President of India, under notification dated 19 December 2018, had assumed to himself the powers of the governor of the state of Jammu and Kashmir. Number 3, that 272 is issued with the concurrence of the government of Jammu and Kashmir, which meant government where Council of Ministers is in place. Number 4, in terms of this CO 272, all the provisions of the Constitution of India are made applicable. Which could not be done as it had not earlier been done by Constituent Assembly. Or by the government of Jammu and Kashmir, or by the governor at any stage in 69 years. Number 5, when it says that all the provisions of the Constitution of India will apply, it would mean Article 368, which carried a proviso with it, would go, and 368 would also apply.
Can you please formulate that again?
Repeat that again.
So when it said all the provisions of the Constitution of India will apply,
Just 1 second. When CO 272 states,
yes, it says all the provisions of the Constitution as amended from time to time, Constitution means Constitution of India, shall apply in relation to the state of Jammu and Kashmir, except the following. That is 367 modified. Who says so?
sorry, what do, I got this part. When CO 272 states that the provisions of the Constitution of India as amended will apply, except Article 367 as modified.
Yes.
What is the sequitur?
It means that Article 368 would also apply, which provides for amendment of the Constitution.
According to you, then, as per 272, 370 was not, no longer applicable.
Look, it says.
That's a secret to your
That
argument.
is the logical conclusion that can be drawn. We want to draw the logical conclusion.
Oh, no.
You want to get.
No, now you're stretching,
No, I'm
you're
just-
stretching it too much.
I am just reading English language, that is all. It is meaning,
You're stretching it.
I'm really trying to find out what is the purpose, what's it leading to.
Very.
I mean, how do we know?
No,
the purpose?
no, it tried
It
to
will
make.
go by the text.
Reformulate the last point. I mean, just for doctrinal clarity, because this
Sir,
last point which you made is not really
Clause 2, sir, kindly see clause 2
of.
of this 272.
Just 1 second.
Clause 2, sir.
Small 2, right?
We'll understand it by the text of it.
Small 2.
All the provisions of the Constitution, that is Indian Constitution, as amended from time to time, which amendments have been carried out in the Constitution of India, shall apply in relation to the state of Jammu and Kashmir. Pause here. So entire Constitution, right from Article 1, right from Article 2 to Article 396, all would apply to us. That's all what I'm saying. And in that 368 would also apply.
Yeah.
Smiling at my justice. It would also apply to us.
And,
Here we come to-
and what happens to 370 then?
So in any case, they have finished 270, was the intention.
No, that
But
was the
what happened
second,
to
that's
the-
the second one. That's a two,
Yeah, I like
not
this.
272,
Yes.
not 270.
They removed the form as well.
Anyway,
They removed the form. Now is the 367, kindly see 367. What does it say in clause C? Reference to the government of the said state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. Just see this. So under 367, advice of the council is also provided in this 272.
Yes.
Now, when council of ministers is not there, yet the governor makes the recommendation. Now see the last part. In proviso to clause 3 of Article 370 of the expression Constitutional Assembly of the state referred to clause 2 shall read Legislative Assembly of the state. We pause here. This is one of the most important controversial part of 367. Now this is being done by the president, who himself was the governor, but mentions it that with the concurrence of the government of the state, he applies 367 in a modified form to us. Now, this is what the learned senior advocates have been arguing, that this 367, whether this can be invoked for purposes of changing the expression Constitutional Assembly into Legislative Assembly. That in turn will involve another question: what is this 367? Which is only one of the provisions of the Constitution relating to interpretation. It says, unless the context otherwise provides. The provisions of the General Clause Act would apply for interpreting the Constitution. That's in simple language, the meaning of 367. Now, going to the main provision of 367, when it says that if the courts have difficulty in interpreting any provision of the Constitution or any word of the Constitution, then the court is entitled to seek aid of General Clause Act. This is
So
what I
really speaking,
understand.
according to you, Article 367 is only an interpretative tool. And what you have essentially done is, by introducing a new principle of interpretation, you have amended the substantive part of 370.
Also, the first question would be jurisdiction, whether they could do so. This will come later, sir, what they have actually done. We are on the question of jurisdiction. Could the president, on the recommendation of the government of the state, where there was no council of ministers, could he make it? I am on the question of power. This is what I'm saying all the time. Second, assuming he had the jurisdiction to do so, then while exercising that power, could he make an amendment in 370 subclause 3 with the aid of 367? Then the second question is, first is whether he had the power, he himself was the governor, having delegated the power to the governor, but under his superintendent's control and directions. It's a very peculiar situation which is done, which is, no, we're not seeing such cases. That is why this case involves certain very issues of considerable importance, because your lordship is dealing with a federating state in a union. We're dealing with the rights of a state, not of a single individual whose fundamental rights are violated. The rights of a state are dealt with. It involves about more than 1 crore people. It involves more than 84,000 square miles of the territory. This case is extremely important, not only in this country, but everywhere. That's how this court will respond to what has happened on 4th and 5th of August, 2019. This, I would submit, is not run-of-the-mill case, not an ordinary case. We are taking time. I am grateful to lordships only for that. But then the cases of such nature, it involves so many considerations, the historical perspective. Without that, no person can understand 370. If he doesn't, he's not aware of the history of the whole matter. Then subsequently, what the governments have done, and ultimately what it did, just like the governments were allowing constitutional application orders, but somebody wanted to have all the golden eggs in one go. So they killed the hen on 4th. Governments were for last so many years giving concurrences, consenting to it. You apply this order, this order, this order, 54 in number. Somebody thought we got to kill the hen and get all the golden eggs.
All right, we've concluded this part now. Can we move on to the next part,
What I'm
Mr. Shah?
submitting is that this was patently without the jurisdiction of the president, and he is acting as the governor.
So you have challenged it on both counts, absence of power, and assuming the power did exist,
Yeah.
the exercise of the power by seeking to amend Article 367.
Now, as a consequence of it, why I said this is the most important notification. As a consequence of it, when you change Constituent Assembly to Legislative Assembly, then things become, you have paved way for getting rid of it, because then now the parliament becomes my Legislative Assembly in terms of Article 357. Because under the President's Order 356, now Parliament has the power to make laws for me. This is the whole constitutional manipulation. Not only that, they use 367 to get rid of 370, and then they kill 367 itself. Because in terms of the second notification, the whole of the constitution is applicable to me, now without any modification, without any exception. You use 367, you alter 370, you take it back, and then you kill 367 itself. This is the manipulation part of it. That's what we are agreed with. It's not a bona fide action. It's not a legitimate action. That is not the way you deal with the states. Whatever may have been the situation in the state, whether it's national security, whether it is anything else, those are the matters of law and order. What is the 370 to do with what happens on the streets of Srinagar or in Kashmir? It has nothing to do with it. May I tell your lordships, all the laws which were applicable to us prior to 2019 continue to be applicable to us. Whether it's Unlawful Activities Act, Prevention of Detention Act, whether NIA Act, they continue to be. The difference is one, they say stone pelters have gone down, the militant activities have gone down. Those are the issues of law and order. I see no connection between that and 370. You got rid of 370 itself. It is not because of 370 those things were happening. There's no connection. Yes, you might have done development after that. There's a different issue altogether. Done or not done, I'm not here to comment on that. But 370, as a matter of fact, as a matter of law, that where a government wants to do something, but there is an obstacle, a constitutional obstacle. Therefore, the government wants to get rid of it. Just like in case of fundamental rights. Just in case of fundamental rights, if there's a fundamental right which doesn't allow the government to pursue a certain policy, then obviously the government has the power to amend that, saying that it cannot be done because we want to have a particular policy. 370 was altogether different. It gave us constitutional autonomy. But then the law and order situation is used as a matter of national security, and these two orders are passed.
Now, what next? Let's cross this bridge. Now we've got this point. The next point, what would that be?
What you want me to conclude immediately, I will.
No, Mr. Shah, please don't harbor that in the least.
We've
So
heard
many
you.
years in judging in a matter like this, I'll not do that unless you are satisfied that you are fully, not just that we should be satisfied that we have heard you, but you must also have that satisfaction.
I had so many things in this matter to say. What you must have noticed, I have not read even a single document.
That's because of your mastery over the subject.
You asked me yesterday, what about instrument of accession? Of course, I could have read the document instrument of accession, but I told his lordship, please see clause 8. If I remember.
I saw clause 7 also.
Read.
I
was reading the documents and then I would have taken 1 week. But since lordships is not going into those
Actually,
documents.
that's why I told you to conceptualize the last point, because now it brings clarity and focus. Those 7 points which you made.
Look at it, everything is covered, nothing is left.
Otherwise, what happens, Mr. Shah, is that typically we make notes based on the dialogue which is taking place. There's always a danger that you lose some point which was made, because the notes are made in the course of the dialogue. When you focus and formulate, then you're sure that you know.
I saw you also making the notes, but sometimes it is not like bullet points as they call it. This is without jurisdiction, because the job of an advocate here is, for example, there is no law on a point. I will have to persuade. Persuasion requires time by us. Persuasion can't be done, sir. President has no jurisdiction. Okay, sit down. That is the end of the matter. I can't do that. How can
But
I
when
do
you're-
that? I
but
got to explain who
Mr.
the
Shah,
president is.
After you've
What-
done, after you have done the persuasion, you have to do the conceptualization.
Yes, yes. That's why lots of I did that. First exercise I have done as a counsel, I have in my own understanding that what could be the ultimate issue, what could be the result of this litigation, where such a serious issues are involved and relating to a state, a federating state, how should this court respond? And not only, there is one more important thing for us. This is the last forum available to the people of the state that I would say that your lordship understands it. There is no one to take it back. As I see the political climate in the country, there's no one to take it back. It remains as it is. So therefore, all eyes are on this court, how this court will respond. And I, as a humble servant of this court, it's my duty to say what people think. The place from where I come, the people think about this 370, what has gone wrong, why are they hurt, why are they disappointed? Something will have to be said because this is a last resort. If assuming, I don't know what your lordship ultimately when the lordship will retire to the chambers and dictate the decision. But ultimately what happens? Either it goes for all times to come, 370 as it is, or we get back what we lost on 4th.
Shah, we have to decide according to law or according to sentiments.
One more thing I wanted to say.
People are happy because of the development, because of the employment opportunities.
Nobody sells a country, sir. Whosoever may be in the government, this is our experience. Whosoever is the government, everybody tries to do his best. All government, nobody sells the country as such. Roads are made, maybe you make it a greater scale, somebody make it a smaller scale. Hospitals are built, education institutions, that all
We
governments.
need not go into all those because
No, sorry, Sir General said so. So therefore, I'm just saying that's all the governments do, of course. Good things always happen.
You're addressing a constitutional argument, and we have to deal with it.
The last one which
Constitutional argument.
I would like to submit because as I see this is an important matter for us in that I remember only one thing, few things I need your lordship to know that. That is sometime back, the great leader of this country, Mr. Atal Bihari Vajpayee, came to Srinagar and he delivered a speech. And he said that the issue of this Kashmir, I am going to solve within the purview of Jamhuriyat and Insaniyat. Unfortunately, the respondents killed both on 5th and 6th August. I would only pray when your lordship retire to the chambers and dictate the judgment in this case. Let the words of truth and justice trickle from your lordship's lips. That's what I would say. We are looking up to you. We have full confidence in this court, and we believe that the justice will be done to the people of the state of Jammu and Kashmir.
Thank you very much, Mr.
If
Shah.
anything is left, I would.
Thank you, Mr. Shah. Thank you very much. Who will be
There
addressing
were
us?
some judgments also which I wanted to cite for every submission which I made.
Can you,
give those-
Mr. Shah, can you just do one thing? On the judgments, they will all be in the compilations which have been
If
filed.
anything is
You
outside
can maybe
that-
give us just 2 pages, a short,
Short.
just a sentence or two why you are relying on the judgment,
I
just as Mr. Subramaniam did. That will help us.
Now I understand. Sometimes it becomes too overwhelming for the judges also. You go on hearing a case all the time.
Not
same
really,
case.
I'll tell you what happens, Mr. Shah, is this, that at the end of it, when, the dust and the din of the court has settled down and you are left with yourself in a small office to dictate a judgment, as all of us do, conceptualization always helps, because that's when you really have to sit back, close everything, shut yourself to everything else but the core of the case. And that's why it helps, actually.
God bless you.
Thank you
for
very
giving
much.
me
You've
a-
done it, you've done it
have these-
admirably. Thank
I
you very
have
much.
these 2 things done. The constitutional autonomy as on 4th.
Yes, please give us that. Yes,
And number 2, also some few judgment, but I will indicate the paragraphs only to support
absolutely.
what was the position earlier, what is the position now. I'm
Thank
grateful to you.
Thank you, Mr.
Thank you.
We'll now have Dr. Dhawan.
Mr. Shah. I don't understand the electronics, my lord. Therefore, I'll have to rely on my friends. Call me a Luddite if you want, but that's the position as it stands.
But I noticed Mr. Shah was also on his iPad. He was pretty up on his iPad.
I
And
can
all
learn
of-
during this process or not is another matter.
Dhawan, the Chief Justice made me do it on the last constitution bench. That was my first endeavor, I must confess.
The practice of each court differs. Some we go with all our files, some we come, my lord, with PDFs. Don't
And
even.
now we are evolving towards this, really.
No, this is a far better system, my lord. It's the question of getting used to it.
Absolutely. Mr. Dhawan, actually, it's the ease with which we have been flipping through documents, volumes, it's only because we are electronic. Otherwise, can you imagine, 5 court masters handing over
And
a new
cases.
volume, then us giving that back to them?
Actually, if there's a brief, then there is no problem. When the brief is many briefs in large volumes, then the utility of this is, I think, much greater, where the records are very voluminous.
And the giving of books, my lord, handing over, flagging them for your lordships to look at. But I'm hoping I'll be assisted, my lord, by my brilliant assistants. My lord, I think when we start with the Constitution of India, we have to recognize that India is the most diverse country in the world. If you take the whole of Europe, the whole of Americas and part of sub-Saharan Africa, you have a diversity, and that diversity is totally and completely unparalleled. And that diversity is reflected in this Constitution. And it is not just Article 370. There are many other articles also, which I will show to your lordship presently, where the legislature of the state's consent is required, or concurrence is required, or it has a condition precedent to put in. And it is this factor your lordship will bear in mind, which will have an impact on other cases. Take, for example, the Podial case. The Podial case concerned whether there should be a reservation for bhutias and lepchas. Now, this was obviously totally contrary to the Constitution, which says that you cannot discriminate on grounds of religion. We got a split decision, but bearing in mind the fact of the history of Sikkim and the fact that the Nepalese were considerably in power, your lordships then took a pragmatic decision as well as a principled decision, which I'll show to your lordship presently, to say, no, despite that particular provision, we have to honor the historical promises made to the people of Sikkim. And this is something your lordship will bear in mind, because our constitution is replete with promises to the people. I mean, take 3 and 4, my lord, to start with. This is the Achilles heel of the Constitution, that there is no territorial integrity. It is so peculiar to the Indian Constitution that we don't find a parallel, as far as this is concerned, in most of the constitutions of the world. Some joined the American Constitution with reservations, like Texas. Most didn't. So you have to bear in mind that 3-4 is such an important provision, and it is central to the argument that I'm going to advance before your lordships. As Mr. Shah has pointed out, this had on the 4th of August a proviso. That is in CO 48. I can take your lordships through that because it's important to understand. This would be, my lord, in volume 3. PDF 13. I'm getting good at it, my lord.
You actually started using the language, you're saying PDF.
Right.
PDF page.
No, no, it's much easier if one masters this. I still believe in the quill pen, unfortunately, Malone. Because I find that whenever one has to write propositions, it is better to write them by hand rather than dictate them.
I would agree with you.
Much better.
Dr. Dhawan, there's one area where I still, despite my love for technology, I'm still conservative, which is when I read a book. When you actually read a book, at the wrapping up at the end of the day, the joy of actually having paper in your hand is.
Well, all that is going to
other.
finish, Malone. I have a huge library, very diverse, not just law. I wanted to give it to the Supreme Court, but there are no takers.
Who said that?
I said that to the Supreme Court Bar Association. This will have Marxism there, Eliot there, all kinds of novels there. If there are takers for it, the only takers at present offer I got was from Chanakya University in Bihar. Because that entire library is a collection of many things. Stuff on paintings, stuff on cinema. Now,
Dr. Dhawan, I mean, apart from this matter, please do walk across to the judge's library and have a word with our librarian, the registrar library, Ms. Uma Narayan. Please have a chat with her. I'll also speak to her.
I'll do that. Let them come and see the library, and whether the Supreme Court should have a purely legal library, my lord, or whether it should have a diverse library.
Oh, we have a diverse library. We
Diversity.
pride ourselves on having books apart from law, actually.
That's right. And that's important, my lord. The question is always one of space, my lord. Nobody today has space. Most of my colleagues, my lord, Professor Galanta, Rick Abel, they all are sending messages, my lord, in Facebook. Does anybody want a library on law and society? It is available. Please let us know. We will pay the expenses for transport. There is no space, my lord. That is the real difficulty that is faced.
I think there's something that
All the opinions and submissions are there, my lord. The unpublished papers are there. There are books that I never published, my lord. But who will want interested in that? Certainly not my children, my lord.
But actually, Dr. Dhawan, you may be, with respect, you might be wrong for this reason, that if you digitize this collection, today there are resources across the world where they are putting this out into the commons. Yes. And the idea is by putting it out into the commons to allow researchers globally to access this. So there's a great deal of interest actually.
My university came to me and said that we'll have to tear apart all these black volumes of yours. And I said, well, let's leave it for the moment.
I think Mr. Venugopal has, through Mr.
Venugopal, excellent
digitized entire library, which is now available for public access. Antiquarian books. He collects antique books. That is digitized and anyone can access.
One of the finest libraries I've seen, of course, Mr. Ashok Sen had a brilliant library. Venu, of course, has a super library. There's a lawyer in Mumbai called Mr. Nadir Modi. I don't know if you ever have walked into his library. He has an amazing library in a place like Mumbai, in the heart of Fountain, where space is such a constraint. But he would never lend his books because he says, when lawyers take my books, they bend the book for photocopying it, and then the binding goes to seed.
We have this side now, beyond Court 5, going, that entire wing is totally vacant, free floor. Where during the COVID, the late Chief Justice Indra Malhotra wanted to donate her father's library. And at that time, we couldn't locate any place, so we went hunting, and that whole thing was vacant. But because of the COVID lockdown, that committee that I was part of couldn't get it, sort of access it. But if a new library could be made on this side, so if you'll also find out, the entire free floors are vacant because everything has moved to everything has moved across the road to the new administrative block.
As you know, we are now in the process of constructing a new building for the Supreme Court in this complex at the back.
They will all come as part of actually Justice plan to have additional building for the Supreme Court. So a lot of it will, is part of that planning will have to go. Maybe something more comes out of it. Space will be created. But you were mentioning with Dr. Aman, the Chanakya University. I had an opportunity to go to Patna and see almost a very large percentage of new judicial recruits in Patna, and very, very eminent people came
Faizan
from.
Mustafa has just taken over.
They came from this university. And I was interacting with them as to how many of them, and very large, I think almost 40% women. And they were a lot of them are products of this university who had got into the judicial service.
Because when I spoke to Faizan, he said, I spent 17 crores in building the library of Nalsa. And I have to do it all over again, so I'm happy with your books. I said, come and see the library first.
Incidentally, Mr. Singh, Mr. Surabji's family gave us his personal collection, the Judge's Library. And in our Judge's Library, we have unveiled a new section called the Soli Surabji Biblioteca. We have a very large oil canvas painting of Mr. Surabji, and to commemorate him and his family when they were vacating the Niti Bagh house. Ms. Zina Surabji called up and said, are there takers in the Supreme Court? So he said gladly. So our librarian went to his house. This was during the pandemic. She boxed all the books, brought them here, and then some Jindal Global Law School too.
What if I find any takers?
Good building in Kerala. We had a library in Tripur. There, of course, most of it were reports. Now, my lord, the judges have, there is a proposal, my lord, to float a trust. And then, my lord, put up a new building. Or in this, refurbish the same old building with, and therefore we are actually looking out for books. Therefore, if Dr. Dhawan's library is available, therefore, my lord, unless the Supreme Court librarian is quick on the day, we might actually tell him. So many offers, Mr.
The
Dhawan,
offer I
short time.
made the CBA, my lord, a few years ago was, please take it. You don't need an oil painting of me. You don't need my name there. Just take it and make sure that the diversity is maintained. If somebody wants to book on Renoir, he should be able to access it from me.
Probably do it at 4 p.m. today.
So, Mr. Dhawan, you have offers from north as well as south. Patna and Cochin,
Right.
Iowa City.
But this has happened. I know a university in Tamil Nadu. I think the former Attorney General gave his full library. A lot of these universities which have been strengthened with libraries donated by councils. GR donated his entire library there. So it's
Right.
It's certainly a place where lawyers can go and do some research. Should not become a samosa pakada place. As I said, short of that, yes. For true research, yes.
That's true. That's true.
And that is the problem.
Now, this is the problem.
This is the problem.
This is the problem which I have. Incidentally, one second. The new building which we are constructing of the Supreme Court, the entire ground floor is going to be used for the library, for the SCBA, library for SCORA, for the Women's Bar Association. That's the whole, my learned brother, Justice Surya Khan, Justice Sanjeev Khanna, Justice Gawai, and Justice Kaul and I were invitee members because we are not on the building committees of our three colleagues. Now just wait for the new building which we are constructing. We are showing it to the
As
SCBA.
technology is going, nobody will have to go to a library to read actually. That's what is going to happen. It's happening already. So that access to information will not be a problem.
So now that's why we have conceived of a new project, right? Our project is coming up now. Yes, Doctor.
Anyway, I was taking the first, my lord, article that I want to show to your lordships to demonstrate the diversity, because it's not just limited to those special provisions from 371A onwards. In fact, for Nagaland and for Mizoram, they say you'll need the legislature of the state to act. I'll show that to your lordships before you interfere with any customs. Now, here is an impediment. It's very different. I'll show that to your lordships. Now, my lord, come to 3 and 4, my lord, to begin.
Article
I want to just show, my lord, volume 3, my lord, PDF 13. This was I'm talking of the CO 48 that brings in the provision, my lord, into Article 3.
Oh, document 3.
Document 3, I'm sorry.
What page? PDF? 1-3. Yes, we got it. 1954 CO.
Now, my lord, straight away at the bottom of that page, you'll see in Article 3, they shall be added the following further proviso, namely, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. Three 68 कहाँ है कौन से पेज पे Mr. Shah was referring to.
We read the proviso with Mr. Shah.
You read the proviso, my lord. I also wanted to read the proviso, my lord, to 368. And then I'll be done with CO 48. That's page 411 at the top, my lord.
PDF page number
18.
18
PDF 18.
in volume 3.
Yes, same volume.
Reading the proviso, Mr. Dr. Dhawan?
I'm going into the bottom of the page, my lord, on part 20, because these are relevant to us, my lord. If the only way out is an amendment, then these provisions are crucial both to Article 3 and 4, to 370, and a possible amendment, if any. I just read that, my lord, and I don't have to read the rest, because much of it has been read to your lordships. To Article 368, the following proviso shall be added, namely, provided further that no such amendment shall have effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under clause 1 of Article 370.
So once there's an amendment to the Indian Constitution, that for the purpose of Article 370 is placed on the same footing as any other provision. So that you have to have a specific amendment
That's right. My Lord,
by an order, presidential order under Article 371.
It's a two-stage process. The first is you must have an order of the President under clause 1. Before that, you can't proceed with the amendment.
So clause D of, subclause D of clause 1 is then made operational. You have to have a presidential order under D.
That's right. That's right. My Lord, I'll come to those points a little later, because whether 370 could be amended at all or 3 and 4 could be invoked during President's rule is a major point that we wish to make at some point in time. Because all the provisions there relate to governments assisted by councils of ministers. As far as Article 3 and 4 is concerned, you have to circulate the bill to the legislature concerned. There is only one judgment of the Delhi High Court which goes the other way, but your lordships have insisted that this is a mandatory condition. This has not been done as far as the invocation of 3 and 4 is concerned. So let me take my lord to 3 and 4.
Here, page 367.
State separating of territory.
Dr. Dhawan, which page are you on? I missed out.
I'm on the Constitution, my Lord.
Article 3 and 4.
I'm sorry, my Lord, I should be more prepared in cross-referencing.
I was probably reading something with.
No. I'll come to my written submission in a moment, my Lord. There is something elaborate on 3-4. Once again, I've quoted from the judgments rather than actually refer to them. I'll give your lordship the PDF numbers. Now, my Lord, Parliament may by law form a new state by separation of a territory from any state, or by uniting 2 or more states or parts of states, or by uniting any territory to a part of the state. Increase the area of a state, diminish the area of a state, alter the boundaries of the state, alter the name of the state. Now, my Lord, the proviso here, it was brought in, my Lord, by the 5th Amendment, as your lordship will see at the bottom of the page, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, unless where a proposal contained in the bill affects the areas, boundaries, or name of any state, the bill has been referred by the President to the legislature of the state, expressing its views thereon within such period as may be specified in the reference, within such further period as the President may allow. This, in my respectful submission, is a mandatory provision. The case law, my Lord, suggests all you have to do is refer the bill. You don't have to refer future amendments to the bill. But this is a mandatory provision. And it will affect, my Lord, the JK Reorganization Act of 2019. Because that is invoked, my Lord, under Article 3 and 4. Territories are changed, names are changed, etc. The 2 explanations I'll omit for the moment, my Lord. They were brought in after Berubari, my Lord, because there was some concern as to whether you can take parts of territories and deal with them separately or not. And therefore, you have explanation 1. In this article, state includes a union territory, but the proviso state does not include a union territory. Now, Mr. Sibal was at pains to apply this particular explanation to the clause 1, my lord. He said there were many combinations. Actually, this did not, explanation 1 and 2 were not applicable to the state of Jammu and Kashmir. Then comes the consequential provision 4. Any law referred to in Article 2 or Article 3, Article 2 is relevant for Sikkim
Contains such provision.
because it joined subject to some conditions which are there in Article 371 in the 371 series. Shall contain such provisions for the amendment of the first schedule and fourth schedule as may be necessary to give effect to the provision of the law, and may also, so first, my lord, is the amendment of the first and fourth schedule, and may also contain such supplemental, incidental, and consequential provisions, including provisions as to the representation in Parliament and in the legislature or legislatures of the state or states affected by such laws the Lord Parliament may deem necessary. Now, these supplementary provisions are what is contained in the JK Reorganization Act. Argument made is you have representative democracy in the Union Territory, you may not have it in Ladakh. But nevertheless, the entire statute is really made under Article 4. My lords, if I may show some other provisions to your lordships on diversity, my lord. This I will explore later when I show your lordships the decisions on Article 3 and 4. Very strange provision, my lord, in Article 164. Well, the special provisions, my lord, on SC/ST, your lordships will see, there is an entire separate chapter on it. And our affirmative action is very different from that of any affirmative action in the world. So 164, my lord. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition, be in charge of the welfare of scheduled castes and backward classes. Now, this came in, my lord, by way of a small alteration for Odisha, the name was changed. But this is an important provision which once again shows the diversity, my lord, that exists. Then, my lord, your lordships will come to Article 244, my lord. My lord, before that, my lord, the Union Territories, if I may just indicate that to your lordships, that's part 7.
239, right? 239.
Now, my lord, all the amendments by and large to creating Union Territories, except for Chandigarh, my lord, have been made by constitutional amendments. Here we see the creation of a territory, my lord, under Article 3 and 4. So let us have a look, my lord, save as otherwise administration of Union Territories. This was put in by the 7th Amendment. On Article 3 and 4, Mr. Chandra Uday Singh, my lord, will take your lordships through the State Reorganization Committee report. Didn't go into that, my lord, because he is going to develop that argument. every union territory shall be administered by the president, acting to such extent as he thinks through an administrator to be appointed by him when with such designation as he may specify. Notwithstanding anything contained in Part 6, the president may appoint the governor of a state as the administrator of an adjoining territory, or where the governor is so appointed, he shall exercise his functions as such administrator independently of the Council of Ministers. So, my lord, as soon as you become a union territory and subclause 2 applies, the president may appoint a governor of a state, he may appoint somebody else, but at the end of it, it says he shall exercise his functions independent of the Council of Ministers. This, of course, has changed, my lord, in the context of Delhi, etc., but I'll come to that in a little. Then, my lord, your lordships will see 239A. Parliament may by law create for the Union Territory of Puducherry a body which is whether elected or partly nominated or partly elected to function as a legislature for the Union Territory or a Council of Ministers, or both with such constitutions, powers and functions in each case as may be specified. Puducherry, my lord, came from a constitutional amendment. Parliament was authorized, my lord, to make a statute, and it did so. The next, my lord, is a provision your lordship is very familiar with, 239AA. That is Delhi, and it contains, my lord, in the amendment itself, not through a circuitous route, my lord, of 3 and 4, but in the amendment itself, it contains the provisions for a legislative assembly, division of powers, my lord, then, my lord, failure of constitutional machinery, and then finally 240, my lord. The president may make regulations for the peace, progress, and good government of the Union Territory of Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. To this, we can now add, my lord, Ladakh, as a consequence, my lord, of the changes that have been made. But of course, it's not amended, my lord. It's done as a consequence of Article 3 and 4. And therefore, the president completely takes over. There is no parliamentary government at all, no reference to the people, and there is a lieutenant governor or a governor in charge. And that is the fate of many union territories, my lord, unless provisions are made. When you convert a state into a union territory, and there is some doubt as to whether you can, because without explanation 1, it is clear we are talking about states. And this would be the only occasion in the history of India where a state has been reduced to a union territory. It is, and now when we talk of transformative constitutionalism, it is important to bear in mind what this really means. As far as Ladakh is concerned, a provision similar to 240 will apply, which is there, of course, in the Reorganization Act. And as far as Jammu and Kashmir is concerned, it becomes a union territory with the limitations that are there in the JK Reorganization Act. This is unprecedented, my lord. If, for example, you wanted to make a union territory of Delhi, there were special reasons, you passed an amendment to the Constitution. Here, by a circuitous procedure, you have converted through Article 3 and 4 two union territories from a state, one with some representative government, one with none. Then, my lord, if I may take your lordships to 244. I'm just, my lord, on the question of diversity of our constitution, which makes it very different from others and more exciting than others.
We continue on Wednesday.
Your Lordship.
The 16th, right?
Wednesday,
Wednesday.
There's a small housekeeping matter. There are additional volumes of case law and documents Mr. Dushyant Dave's team have given. In fact, it appears that they had given, because there was a Google form, it might have been missed out by them. So request that that also be taken on record. There are about 3 cases.
But were they given in advance with the other volumes?
Yes, yes, it is. We had a
The nodal
Google form,
council?
which is-
So the
we
nodal
don't
council-
seem to have the record, but it appears that they had given of the other volumes. Case law. It was case law and documents. One.
Is there any overlap with the case law and documents already on the
We've done
record?
the deduplication. There is no overlap.
There's no duplication. All right. Okay.
And there is also a chart of intervention application, the essence of intervention that.
All right. That we'd like to have, so that we'll, at a glance, we'll
That
have
also
the.
I
Certainly.
obliged.